Thank you so much, Corey and Kevin, for those gracious introductions, and thanks to the audience for the warm welcome. I am just really honored that so many of you are taking time to partake of not only food, which I'm sure is a big attraction, but also food for thought. I love tweaking my friends in the Federalist Society that I am not now, nor have I ever been, a card-carrying member of the Federalist Society. I am a bleeding heart liberal. And, I'm not saying but, and I have enthusiastically supported the Federalist Society's mission and enthusiastically participated in Federalist Society events from the beginning. So I like to look at, after all these years, the brochure for the Federalist Society Student Division. On page 1, there is somebody else. It is Ronald Reagan. But I'm on page 2. And my dear departed friend Nino Scalia is only on page 3, but who's counting? In all seriousness, the Federalist Society, first of all, it is a group of libertarians as well as conservatives, and I know that you have a lot of debate and discussion among yourselves, as certainly we in the ACLU do. I'm very familiar with that, but very often I find myself in agreement with those of the more libertarian wing of the Federalist Society. But that aside, even assuming hypothetically, I disagreed 100% with 100% of your membership and your positions, I would still applaud this organization because at the time it was founded, there was really, there was nothing comparable that spurred debate and discussion about the issues that are so important, not only to all lawyers, but to all people. And I'm not just going to say all Americans, to all people everywhere, and that subject is the values that in our country, fortunately, are reflected and protected in the Constitution. Later on, as your organization has flourished and become such a remarkably powerful force in our judicial system and in our political system more generally, I like to tweak, again, my friends in the Federalist Society, that the single greatest contribution you have made is spurring the formation of the American Constitution Society. Oh, you're not laughing. Well, but I do think it's a very, very interesting phenomenon. And today's law students are probably not familiar with, at the time the Federalist Society was founded, the conservative philosophy and libertarian philosophy were so minuscule to the point of non-existence in the law school culture that that's why it was formed. And then it became so successful, the pendulum swung so far that the ACS was founded to try to be a counterweight. Anyway, I certainly hope and believe that the topic of my book is something that should be supported enthusiastically by everybody, no matter who you are, no matter what you believe, no matter where your ideas shake down across the ideological spectrum. I hope you will support the principle of individual freedom of speech, the right to choose what we care to say ourselves, what we care to listen to, what we care to respond to, what we care to disagree with, what we choose to debate against, what we choose to ignore. Ultimately, those decisions have to remain in our individual power, not only consistent with individual liberty, but that is actually a bedrock prerequisite for a functioning democracy, where we, the people, are the governors. How can we effectively and responsibly exercise that sovereign power and hold accountable to us those that we elect to represent us, unless we can have robust, vigorous debate, especially on issues that are deeply sensitive and controversial and likely to provoke charges and countercharges of hate speech. Now, I put that term in quotation marks throughout my book, and I will spare you the air quotes from now on, but please imagine them, for this reason. As the lawyers and judges and law students here know, there is no such concept as hate speech. And in fact, I know that the law students here know this because as I was flying down, I read some excellent pieces that had been authored by students, both in the Campbell Law Review and in the Campbell Law Observer. And in the Observer, a couple of years ago, there was a fantastic unsigned student editorial which was entitled "To Speak Freely, the College Campus Debate." And it showed a really firm grasp of First Amendment principles that are not nearly as well known as they should be, and to the contrary, are constantly misstated, even by politicians, some of whom graduated from law school. I think none of the culprits graduated from this law school. That might explain it. So I have to credit Dean Leonard and Professor Wallace for teaching all of you very well. But let me just give you a refresher. There is no specific legal term of art or concept of hate speech, precisely because the United States Supreme Court never has defined and labeled a category of speech based upon its hated or hateful content and said, therefore, speech that meets this definition is going to be excluded from First Amendment protection. So it's completely different from, for example, obscenity, which is a constitutionally recognized term of art. The Supreme Court has given us a very precise, quite precise definition, which I'm sure all of you law students could recite. And if that definition is satisfied, the Supreme Court says that that speech, which is a subset of sexually oriented speech, is just completely unprotected by the First Amendment. The Supreme Court never has done that with respect to speech that conveys hateful or hated ideas. To the contrary, the court has espoused what was originally a dissenting view by Justice Brandeis, cited and quoted in this wonderful piece written by one of your co-students here, that the answer to speech whose ideas we loathe is not to suppress them, but rather more speech, counter speech. Now, I want to say more about the legal principles in a moment, but for now, I want to stress that the argument in my book as to why we should not censor hate speech, and I'm sorry, I have to put a parenthesis here. I told you hate speech is not a legal term of art. I'm going to use that term the way most of us use it most of the time, which is speech that conveys discriminatory, hateful, or stereotyped ideas on the basis of race, religion, national origin, sexual orientation, and so forth. The reason why I argue that hate speech should not be subject to censorship does not depend upon the First Amendment principles. I think the First Amendment principles are correct, among other reasons, because they most effectively allow us to counter the hateful attitudes and that are reflected in hate speech, and to prevent those attitudes from being perpetuated, and to prevent hateful or discriminatory conduct or violence. In other words, I make an argument that is completely founded on strategy, policy, pragmatic concerns, and the reason I do that Well, there are several reasons. Number one, I believe that these arguments are universal. These debates are universal. They've been flourishing throughout my entire adult lifetime, literally around the world, in other developed democracies and in new democracies and in authoritarian countries as well. And these are perennial issues of human concern. So I want my argument to resonate all over the world, including in countries that do not have a First Amendment or a counterpart to the First Amendment. I also want my arguments to resonate in the private sector. And here's another constitutional law lesson for those of you who have not yet had the privilege of studying it with one of your great faculty members. And that is that the First Amendment, along with other constitutional rights, pertain only to the government. You have no First Amendment free speech rights against any private sector entity, including a private sector law school, including a private sector employer, including a private sector media or social media outlet. And yet we're living in a world where dominant power over our communications is being exercised by powerful private sector entities. In fact, in a case that came to the Supreme Court from your own state of North Carolina last year, the Packingham case, the Supreme Court, which is rarely unanimous on any constitutional issue, including many First Amendment issues, the court is deeply fragmented. But in that decision, the court was unanimous in stating, among other things, that the most important forum for the exchange of ideas and information, not only among our communities, our friends, our families, but also with government officials and about public policy, that the most important media are the social media, and that they are occupying the traditional public square, public forum that used to be occupied by streets and parks and sidewalks. So if we are not to have free speech in those domains for all practical purposes, we won't have meaningful free speech at all. Let me give you just one statistic that I included in my book, and because the publishing process is slow, so I turned in my manuscript in August of 2017. So the number is outdated. It's an understatement. But way back then, Facebook said that every single month, enforcing just its policies against hate speech, and we're just talking about one social medium, one type of disfavored speech in 1 month, taking down 288,000 communications each month. And again, I'm sure that number has been way dwarfed in the interim. So all of the arguments I make apply universally to private sector as well as public sector, to governments other than the United States. And one of the things that I learned from doing the research on my book, before I tell you what I learned from doing the research on the book, let me tell you about my motives for writing the book, because I think it's really important that you understand the personal as well as the human rights passion that infuses this message. I think it's well summarized by the book design. You know that old statement, a picture is worth 1,000 words, and I didn't have that many words in the book because Oxford is imposing very strict word limits. Nonetheless, the cover conveys the ideas, the essential ideas, very succinctly, and I had nothing to do with it. It was presented to me as a fait accompli, and I thought I really hand it to the designers. So first of all, that ugly word in big, black, bold block letters, hate. We have a lot of disputes about statistics in this area. It's hard to know how many hateful incidents there are, how many are reported, but there's no doubt that there are too many, right? And they've been flaring up not only in the United States, but all over the country and all over the world, I'm sorry. In terms of very dramatic, brutal manifestations that have erupted into hateful crimes and even deaths of people. So that's a very serious problem that I wanted to tackle. My personal reason for wanting to tackle it is resonant with the color and the design here, which to me connotes a not only a placard or an armband, but in particular the colors to me connote Nazism and fascism. So I like to tell audiences a little bit about my personal family background. My father was born in 1922 in Berlin as what, under the Nuremberg laws that Hitler propounded later on, viciously racist laws that defined everybody into certain categories. And my father, I went with him to the Wannsee Conference Center where the conference took place, where they came up with these racial definitions. Then they even had diagrams, and you could imagine the diagram of a Jew. It showed, you know, the racial caricatures of Jews. And my father was classified as a Jew of the second degree because his mother was by background and family history Jewish. His father was, quote, Aryan, close quote. His mother actually came from a very old, previously Jewish German family called the Meyer-Mendelssohn family, which, yes, is the same family that gave rise to Felix Mendelssohn, the great composer. But they had not been practiced Judaism for generations. My father was raised as a Lutheran. I'm going into the religious history because I know that there's a religious affiliation between Christianity and this wonderful university. So my father was actually raised in the Lutheran Church and confirmed by the famous pastor Niemöller, who was a famous resistor to Nazis. And he and his brothers had no idea even about their family history when they are branded as Jews of the second degree, and the older ones, including my father was the oldest, put into the Buchenwald concentration camp. He was also politically active against Hitler as a teenager. I'm very proud of that. When he went into the camp, my father was young enough and healthy enough that they targeted him for slave labor, doing back-breaking labor. They didn't immediately slate him for death, but the conditions in the camp were so horrific. Disease was rampant and malnutrition, and people were dying like flies. It was just a matter of time before he would have died, and even shorter time. Literally, the good news is obviously he made it out, but just by one day in terms of my fate, because he was liberated by the American military one day before he was scheduled to be sterilized by the Nazis. So I literally owe my life as well as my liberty to the American military, and I love speaking to military audiences and law enforcement audiences. We have issues, disagree on particular issues, as all too thinking people and organizations do, but I see that we're all embarked on the same fundamental values, right? Every member of the military takes an oath or affirmation to uphold the Constitution, and that's what I've been trying to do in my own way. So, going back to the title or the cover of the book here, the subtitle, why we should resist it with free speech, not censorship. When my husband first saw this design, he said, you know, I think the subtitle is a little bit too pronounced. It's hard for people to see the word hate under it. And I said, yes, that is exactly the point. I really do believe, am convinced based on evidence that we can and will overcome hate. And the only way to do it effectively is not through censorship, but through counterspeech and other non-censorial measures. And for an extra prize, what is the script in which that subtitle is written? And I say extra script because I confess I didn't notice it at the beginning. After decades of teaching the US Constitution, that is exactly the font and script in which the Constitution itself is written. So again, I think the jacket designer brilliantly captured my idea. Now, I was starting to say, I'm going to tell you a couple of things that I learned by writing the book. I have studied and advocated on this issue forever, going, well, not quite forever, but as far back as I can remember, certainly including shortly after I graduated from law school in 1975. The ACLU in 1977 took on a case which now epitomizes the American approach to defending freedom, even for the thought that we hate, to quote Justice Oliver Wendell Holmes, the so-called Skokie case. That's what got me started on this. I have re-examined my position, I believe, with an open mind, but the more I look at it, the more I conclude that censoring hate speech, no matter how well intended, actually does more harm than good, specifically for the goals that are advocated by proponents of censorship, and I completely support those goals as well. Equality, dignity, diversity, inclusivity, societal harmony, and individual mental health. I think all of those goals are best served through a non-censorial strategy. So the Skokie case, for those who aren't familiar with it, occurred, as I said, in 1977. Skokie, Illinois is a suburb of in the Chicago area that has a large Jewish population. At the time, a large number of people who lived in Skokie were Holocaust survivors. 1 out of every 6 people who lived there then either was a Holocaust survivor himself or herself, or very closely related, say, you know, a spouse or a child of a Holocaust survivor. So when my organization, the ACLU, did what it has done since its beginning, almost 100 years ago, to defend freedom, even for the thought that we civil libertarians hate, and having been on the forefront of equal rights and against discrimination and in support of all civil rights causes, of course the Nazis' ideas were completely antithetical to civil liberties principles, but we really did believe in effectuating that precept that has been attributed to the philosopher Voltaire. I may disagree with what you say, but I defend to the death your right to say it. And in part because we understand that all rights and freedoms are indivisible. If the government has the power to violate one freedom for one person or one group in one place, then that's a power that's going to be used against another freedom of another person or another group in another place. Indeed, in the Skokie case itself, where you had Nazis who were demonstrating against Jews and against African Americans, and by the way, given my Jewish heritage, I'm very proud that the specific reason that the Nazis were citing for hating the Jews was they blamed us for being major advocates and proponents of racial equality and leading a charge together, of course, with members of racial minorities, other racial minorities, leading the charge against segregation and discrimination. So, sometimes you wear that criticism like a badge of honor. Anyway, one of the things that we pointed out in our brief was the very same arguments that were made in support of shielding Skokie and shielding the Holocaust survivors from the insult and the trauma and the offense and the potential danger and violence of the Nazis demonstrating there, that every single one of those arguments had been raised in an attempt to justify keeping out another group of demonstrators from another Illinois town just a few years earlier, namely Cicero, Illinois, which is in the southern part of the state, pretty much a part of the South, very segregated, very opposed to the civil rights movement, wanted to keep out the Martin Luther King civil rights movement from demonstrating there because they felt that the ideas were offensive to them, were threatening their way of life, were subversive, might well promote violence, were insulting, made them, traumatic, etc. So in the Skokie case, the ACLU won that case. It was a slam dunk victory. It went all the way up to the U.S. Supreme Court, which affirmed rulings by both the lower federal courts and by the state court system. It was a slam dunk winner because what was at stake was what the Supreme Court has called the bedrock principle of our free speech jurisprudence. And for those of you who have studied it, that's a big deal. You know that there are just thousands and thousands of cases and decisions and rulings and principles and caveats and exceptions. It's a very complex morass of law. And yet the Supreme Court has reaffirmed and reaffirmed that all of it is built on this one bedrock principle, which the court has called content neutrality or viewpoint neutrality. And that means that government may never suppress speech solely because of dislike of its viewpoint, its message, its idea, its content, no matter how deeply despised or feared or hated by no matter how broad a section of the public or by the government. That alone is never, content alone is never a sufficient justification for punishing the speech. So it was an easy win in the courts of law. But in the court of public opinion, it was extremely unpopular and unsuccessful. And I like to remind people of this because I'm often asked today about today's college students or even law students, and I often read statements in the press that make assertions, condemnatory assertions that today's students are snowflakes or they're little authoritarians and they, have a unique disposition to suppress hate speech or ideas that they hate. And I have to say, hey, wait a minute, I do think there is too much support for suppressing hate speech, and that's exactly why I wrote my book, to try to change people's minds on that. But it is support that is not at all unique either to students today or to students today. In other words, throughout my entire adult lifetime, and I'm sure back much further than that, the vast majority of the public of every age, it wants to suppress hateful ideas. Even card-carrying ACLU members, right? Who is more devoted to robust freedom of speech, even for controversial ideas, than people who care enough to join the ACLU and pay their membership dues. By the way, the membership dues are very low. Okay, end of commercial advertising. And yet, back in 1977, we lost 15 15% of our members. So when people say there's something unique about today's students, I say, no, wait a minute, you know, those ACLU members were not students, and it's an understandable and I will say commendable human instinct. I always see the glass half full. As an activist, I do, but seriously, the impulse to suppress hateful ideas through censorship is why I am so optimistic that we will, in fact, suppress hatred, hateful attitudes and actions. And I'm very confident that we will do so through free speech, not censorship, precisely because I know that the vast, vast, vast majority of us are committed to liberty and justice for all, do feel a moral responsibility to oppose discrimination and censorship, yes, both. And I also am very hopeful that we can win over even those who do not share those values. I am absolutely convinced that our only hope for winning over those who do not yet share those values is not through treating them as criminals, not through shaming them or humiliating them or treating them as exiles from the community, but rather reaching out to them with empathy and compassion. So I was going to tell you that there are a couple lessons that I learned from writing this book, even though I've been advocating the same position going back all the way to Skokie. I decided to write the book, as I already indicated, in response to public opinion surveys and anecdotal evidence that indicated that today's social justice warriors, and I say that as a compliment, I know some people use it as a criticism, but what's better than going to war for, well, I guess going to peace for social justice would be even better. So let's say social justice activists. Having been a campus activist in the 60s and 70s for racial justice and women's rights and anti-war and various other causes that are still dear to me, for the intervening decades, I was kind of disappointed that college students were very apathetic on the whole. And surveys, there's an institute at the University of UCLA has done a survey of every single incoming college student starting in 1967, literally every single one, and it's very comprehensive about their attitudes toward many important issues, including political issues. And for decades, it showed that most incoming students were not even interested enough in public policy issues to even watch the news, let alone to vote, let alone to become more actively engaged themselves. So I was absolutely thrilled at the resurgence of student activism that began about 2014 to 2015 in response to widely publicized incidents of injustice in the criminal justice system. And again, I can't be a more strong critic, nor can the ACLU, of police abuse and unjustified killing, especially of young, dark-skinned men. But I never make that point without saying something that I would hope would go without saying. But in our divided political sphere, I feel it has to be said that the vast majority of law enforcement officers do their job with tremendous courage and integrity, and they're putting their lives on the line to protect life and liberty for all of us. And I know they join me and other critics in bemoaning those who commit abuse because it undermines their mission. Anyway, the silver lining to the cloud of well-publicized incidents of abuse was a wellspring of activism on campus. And that UCLA survey for the last few years has shown record numbers of students coming in that are committed to working for whatever they consider justice to be. And let a zillion flowers bloom. Maybe some of them will become Federalist Society activists or John Locke activists. That's fine. And they feel a commitment to do that, not only while on campus, but also in the larger community, and not only while students, but after they graduate. So that's wonderful. But there were too many other surveys and anecdotal incidents, many of which have been well publicized, that indicated that they thought that free speech, rather than being, as I'm convinced it is, they're a time-tested essential ally, they saw it as being negative. So I set out to write the book in the hope of reaching today's activists. And the two major conclusions that were reinforced, conclusions I had reached before, but since the last time I wrote in depth about it, or researched in depth, there's a lot more evidence based on every country around the world, to the best of my knowledge, without exception, other than the United States, does outlaw hate speech. And we now have decades of experience in what has happened as a result of those hate speech laws. And it has reaffirmed what I observed from past information, including what happened in this country before we started strongly protecting free speech, including hate speech. And that is that disproportionately these laws suppress the voices of the very minority groups that are anticipated or hoped to be benefited by the law. And certainly the most vulnerable are any critics of the government, including those who are advocating for racial justice and against government abuse, including police abuse, and for any empowerment of minorities. And so when you think about it, it's predictable. It's not a coincidence that we see these enforcement patterns because the concept of hate, which is an emotion, is inherently subjective. So the concept of hate speech is inherently subjective. And therefore, giving to the enforcing authorities essentially unfettered discretion to decide what speech will be punished and what will not be punished. I agree with the analysis of the problem by those who advocate hate speech censorship. I'm aware and deeply troubled by studies that show endemic, systemic, racial, and other bias in the criminal justice system. Studies have been done of the civil justice system, which also show structural biases, including on the basis of gender. We've all heard a lot, and I've read a lot about so-called implicit or unconscious bias that, not surprisingly, given our society and culture, affects all of us. Now, the good news is we can overcome all these problems, and I believe that we are making progress toward overcoming them, but we do know that the laws that exist are being disproportionately enforced. Let's take the drug laws. Study after study, including in this state, show that those laws are disproportionately enforced against, in particular, young, dark-skinned men. So why in the world would we expect anything else when we hand over an even more subjective, discretionary law enforcement power to the political establishment, which is accountable to majorities, not to minorities? Now, all of us probably has our own idea of what, if we were in charge of enforcing the law, what we would consider to be hate speech that should be punished. But let me give you some real-world examples. I'll just stay with the example of police abuse and reform of the criminal justice system. So Black Lives Matter advocacy has been attacked as hate speech. Government officials in a number of states have called for punishing Black Lives Matter advocates, including in Dallas, where 5 police officers were killed in 2017, and there were members of the state legislature there were saying that Black Lives Matter demonstrators should be punished and be held responsible even for a hate crime against the police officers. And speaking of police officers, some people have contended that Blue Lives Matter is hate speech that should be punished. On many campuses, the phrase all lives matter has been targeted as hate speech. On some campuses, really chillingly to me, the phrase free speech has been targeted as hate speech. You know, you name it. I give many, many examples in my book. It's all documented. The end notes are on my website. I didn't want to make the book too long, but it's all very well documented. And basically what it comes down to as whatever idea I hate, that's what I think should be hate speech. And I give a very diverse array of examples because I want you to understand that regardless of what your own views are, speech that expresses those views is going to be endangered. Let me give one example that should be particularly pertinent here given your Christian connections. Under the hate speech laws in Western European democracies, and for that matter, Canada, Australia, New Zealand, countries that are very comparable to ours, a lot of Christian preaching has been prosecuted as hate speech. Same thing true for certain Islamic preachings. And to me, chillingly, there have been a couple of cases where in one case there was a prosecutor, in one case there was a judge who literally told a minister of a Christian denomination that he or she should not preach from the Bible, should not read certain Bible verses, should not use certain editions of the Bible. I mean, that gives me absolute, I still get chills to think about that degree of interference with not only freedom of speech and thought, but also religious liberty, which we prize so much. But it shows one person's, so in fact there was a European Union commissioner whom I actually debated in Brussels this spring. I call her the censorship czar. She has a different title, actually. But she gave, it was just absolutely horrific. She gave a speech, and you can see the exact quote in my book. I'm not distorting it in any sense. And when I debated her, I read her that quote, and she said, yes, I said that, and I still mean it. That she said she was not going to allow religion to be brought forward as a pretext for saying hateful things against homosexuals or against women. So in other words, she was accusing people who have sincere religious beliefs. I'm sure you know those religious beliefs are inconsistent with my civil liberties principles, but I wholeheartedly defend people's right to have those views, to express those views, and to act on those views. That's the essence of liberty and equality. But she actually said, accused them of lying, which I looked at her very, very broad definition of hate speech. She was engaging in hate speech on the basis of religion, right? It's a bottomless concept. So the bad news is that censorship doesn't work. In Europe, there's just been an upsurge. Excuse me. I've got to make my glass half empty now. There's been an upsurge of not only hate speech, but really vicious violence, including anti-Semitic, anti-Islam, anti-refugee, anti-immigrant, anti-Roma. I'm going to self-censor soon because I want to have plenty of audience discussion. But the positive side, where I was also pleasantly surprised, is to learn how effective many, many forms of counterspeech can be. Counterspeech is a very elastic concept. We strategically make decisions about what form will be most effective in what context. And what was most moving to me, as I indicated earlier, are that one can not only try to persuade people not to be wooed by would-be recruiters for hate groups, but that one can actually successfully wean away even confirmed leaders of hate groups. And there's actually, this is such a burgeoning movement of former hate mongers. In fact, they call themselves formers. And there's a whole genre now of TED Talks and books. I'll just cite one of them, a gentleman named Christian Picciolini, who spent most of his life as a leader of a violent, hateful skinhead group. And he, through empathy and compassion, and I think of my Christian friends who always say, hate the sin, love the sinner, is that kind of strategy, worked. And he became a co-founder of something called Life After Hate. He's a full-time, it's an organization that's based in Chicago. He's a full-time recruiter for that. So far, or last time I looked at the numbers, they had recruited away or redeemed more than 100 former hate mongers, all of whom are now doing that. And you, as lawyers, I'm now speaking to law students in the audience and lawyers in the audience, have especially powerful voices because of your education. I think especially those of us who disapprove of censorship have a particularly strong moral responsibility to raise our voices against hatred and discrimination. And I have to tell you, it is so powerful. It is powerful for the victims, it is for would-be victims, it's powerful in reaching out to those who might be on the fence and whether to adopt these arguments or not. And I put my hope there, as civil rights leaders throughout our history have. The epigram I have 3 epigrams to my book. All of them are in this spirit. I'll end because I want to turn it over to you for questions. So I'll just quote one of them, which is Martin Luther King Jr. And he said, in the end, more than the words of our enemies, we will remember the silence of our friends. So I'm going to urge all of you to recall the right that the ACLU celebrates as the most important right on my favorite ACLU t-shirt, which is, you have the right not to remain silent. Thank you very much. And the mic is being wielded, and while the first person seizes it, I want to thank Grant from the Law Students Federalist Society and Kevin from the Lawyers Chapter. You did a fantastic job in organizing this. Thank you so much.
I'm just curious about your thoughts on hate crimes, because it's an element of a crime that is strictly thought. And do you think that should be punished?
This is, I can't give a short answer to this question. Please forgive me, and I'm so happy you asked the question. Unlike hate speech, there is a concept that the law has recognized called hate crime or bias crime, and that is when you have an action that is independently a crime, punishable as a crime, having nothing to do with the idea behind it, such as an assault or a vandalism. Hate crime doctrine or theory says you can treat it as a more serious crime, warranting a heightened punishment when the victim is intentionally singled out for a discriminatory reason. So if a mosque or a synagogue is targeted for vandalism, that could be punished as a hate crime. And not just plain vanilla vandalism. If a trans person is assaulted because of discrimination on the basis of gender identity, that can be treated as a hate crime. The theory is that the discriminatory selection of a victim does more harm both to the victim and to society. Do you mind telling me your name, by the way, the questioner? Roy, may I say Roy, and you call me Nadine? So Roy's question, the way you ask it, you're making the case that it should be as problematic. Maybe I'm reading too much into it, but the way you phrase it makes a very plausible claim that a hate crime should violate the First Amendment because the added increment, the incremental punishment, is due to the thought right? You're creating a thought crime. That is a very plausible argument, which was made by a sizable percentage of the very disputatious ACLU National Board. I told you we have disagreements among ourselves. And the other position, which ultimately prevailed, but only by a hair, and not among all ACLU groups around the country, because this is a very, very hard issue. The other way of looking at it is this is an anti-discrimination law. And in this country, it is completely legal to discriminate on most bases, right? We have employment at will, for example, which means that an employer can fire you for just about any reason or no reason unless it is a certain discriminatory reason, right? The 1964 Civil Rights Act and state anti-discrimination laws say, you know, if you refuse to hire somebody or fire somebody because of race, gender, religion, or so forth, that is illegal. So the anti-discrimination view of hate crimes is you take something that's already, so if we can make something that is completely legal, refusing to hire somebody, and make it illegal when it's done for a discriminatory reason, even more strongly, we can take something that's already illegal, already a crime, such as assault or vandalism, and make it a more serious crime when it is committed for a discriminatory reason. I think those are very plausible arguments. The Supreme Court came down against the First Amendment argument there. But I have to say we have to be very, very careful that the evidence that's used to show the discriminatory motive has to be tightly and directly connected to the particular crime. You cannot allow it to degenerate into just because somebody once made a racist statement or once read a discriminatory book is not enough to treat any crime they commit as a hate crime. Hi.
Hi there. Thank you for coming today. I really appreciate your talk.
Thank you. And can you tell me your name too?
My name's Matthew.
Hi, Matthew.
I was just curious, since we're talking about hate speech, it often involves identity politics. Mm-hmm. And I was just curious if you think that political organizing around identity politics is viable moving forward, or if you think it's leading to further polarization of our country.
Oh, boy, Matthew, what a tough issue. I know that there have been, just in the last week, I read reviews of 2 whole new books about this issue. And a friend of mine, Mark Lilla at Columbia University, wrote a book about it last year. So I can't pronounce. It has definitely divisive potentials, which are very troubling to me. Let me tell you, as a civil libertarian, I have kind of what might seem as paradoxical views. On the one hand, I emphasize what we have in common as human beings. And I do hold very dear the aspiration in our foundational document, the Declaration of Independence, and one of the reasons I like the Cato Institute edition of the Constitution, which I have to thank my friends from John Locke for bringing me a copy. Somebody took my copy at my last speaking engagement. It includes the Declaration of Independence, which one of my friends has called America's birth certificate. And obviously we were very far from the ideal, but all men, by which it was clear they meant all human beings, are created equal, endowed by their creator with certain fundamental rights. And so that, to me, that's what we all share, and that, to me, is far more important than, and we are entitled to equal rights by virtue of our shared humanity. I really want to emphasize that. On the other hand, as a civil libertarian, I am so much in favor of individual rights, and so I'll use the word snowflake in that different sense. I've been taught that no 2 snowflakes are identical. I think that's true of every individual. So I think we also have to celebrate our individual difference, and there are different tributaries that feed into that. Obviously, my ethnic background and religious background is very important to who I am. So it can be a force, as with everything, it can be a positive force or a less positive force. Thank you, Matthew. Hi.
Hi, my name is Don.
Hi, Don.
And I was just wondering if you could update us as to the legal posture of various universities passing some level of controlled speech rules, and where the ACLU is in that?
Excellent question, Don. So Don is referring to a movement that began in the late 1980s of colleges and universities adopting so-called hate speech codes that prohibited what students could say and punished them on the basis of viewpoint, that there were certain prohibited viewpoints. The ACLU, I'm proud to say, not only lobbied very hard for universities not to adopt those codes, but we were first out of the gate to challenge the first such code that was enacted and enforced at the University of Michigan in a case called Doe versus Michigan, which is still the leading case. Again, quite frankly, it was an easy case, I'll admit. It was brilliant lawyering on the part of my ACLU colleagues, but you didn't have to be that brilliant to get a court to enforce, again, this tried and true bedrock principle. One of the things that's very interesting about that case is that for people who think, oh, well, you know, these hate speech laws that have been written in the past, they weren't any good, they caused problems, they were too vague, they were too overbroad, but I could do better. Well, all of those codes, including at the University of Michigan, were written by the First Amendment experts on their faculty. And I'll name names, as I have when I've written about this. Lee Bollinger, who's now the longtime president of Columbia University, a vaunted First Amendment expert, was on the faculty then. He became dean of the University of Michigan Law School. He and other constitutional experts there and elsewhere did their very best to write as constitutional a code as they could, and every single hate speech code from that one on, because you have to admire the persistence of University General Counsel, I guess. You know, there have been dozens of cases, and every single one has been struck down as either unduly vague or overly broad. And during the oral argument in the Michigan case, that pioneering case, federal judge Avern Cohen got the university's counsel to acknowledge what you all know, that we have no right not to be offended. So offensive speech is protected, but the university used typical language when it said, but demeaning or disparaging or degrading speech won't be protected. And so Judge Cohen said to the university's lawyer, how do you distinguish offensive speech, which is protected, from disparaging speech, which is not protected? And the lawyer's answer was brilliant. He said, very carefully. And, you know, and the ACLU continues to take that position, but in the meantime, and we occasionally go to court over it, but in the meantime, as often happens with issues that develop, you know, a momentum of their own, a new organization was founded that I'm very close to, FIRE, the Foundation for Individual Rights in Education, which can deal with this full-time because it is a more than full-time job. And all of you lawyers, I guess this, and law students, this is good for us. Legal issue is never settled. You have plenty of opportunities to continue to go to court to fight it over and over again. Hi.
Your book seems to be written for an area of civility. Mm-hmm. I'd like you to address the area we're in today, mm-hmm. where students are making demands of mm-hmm. colleges across the country, mm-hmm. and the colleges, for the most part, are just submitting. Mm-hmm. It reminds me of Mark Rudd at Columbia, mm-hmm. when they took over Columbia, they took over the chancellor's office. Mm-hmm. And this is much worse than then. And could you address that, please?
Sure. Could you tell me your name, too?
Tony Bruno.
Tony, hi. So I have a number of responses, Tony. First of all, it is not nearly as bad on campuses in general as we infer from the highly publicized and deeply deplorable incidents that we can all rattle off. But think about it. It's the same episodes over and over and over again. And I am absolutely convinced, I speak on about 4 campuses a week, and I'm in touch with many more, and every day I read the Inside Higher Education and the Chronicle of Higher Education. I'm using a phrase that, Tony, you and I seem to be contemporary, so this will mean something to you, the silent majority. It used to be used in a very different way, but I'm happy to report that my very strong impression shared by others is that unfortunately, too silent majority of students and faculty members are hungering for civil and open discourse and respectful debate and dialogue and hearing people with different perspectives. And I understand I defend freedom of speech for the media, but let's face it, if it bleeds, it leads. And the analogy is if there's a riot or censorship, it gets covered. If somebody provocative and unpopular and controversial speaks without disruption, it's not a news story. So you would be amazed at the number of places where the Ann Coulters or the Milos or the Richard Spencers, Steve Bannons, et cetera, have spoken without any ripple. And in fact, that's part of the reason why one very important counterspeech strategy for those of us who oppose some of the messages that some of those speakers might be purveying is to resist the temptation to have a confrontational protest. That's just feeding into their strategy of trying to get attention. But what I think of as a very serious problem on campus now is the growth of various bureaucratic structures that have a vested stake in perpetuating a sense of victimhood on the part of students. And that's a related subject. So I do think there are problems on campus, but I'm not as worried about the students or the faculty as I am about administrators, which have just absolutely burgeoned and do not share the commitment to academic freedom. They have other values are foremost for them. Thank you. Hi.
Thank you for your time. My name is Dan Gibson.
Hi, Dan.
My question is about the fighting words doctrine.
Mm-hmm.
I've seen it argued that you can put hate speech under that category. What do you think of that, and how does that affect your analysis of these issues? The
fighting words doctrine was recognized by the Supreme Court in a case in the 1940s, I believe it was in 1947. Somebody can correct me if the exact year is wrong, the Chaplinsky case, and never once since then has the Supreme Court ever upheld a so-called fighting words conviction. In fact, in case after case after case, it's narrowed the doctrine to a vanishing point and never held that very demanding standards were satisfied in a particular case. Basically, the fighting words doctrine has become a subset of what we think of as an imminent incitement of imminent violence, which can be protected. It's when specifically the danger is caused by targeting, fighting, or insulting words at a particular person who's likely to imminently then strike you back. And that doesn't make sense anymore now that the Supreme Court has vetoed the idea, no pun intended, of the heckler's veto, that we're not going to punish the speaker because somebody else is engaging in disruptive or violent conduct. So it's deeply inconsistent with many, many subsequent cases. As I always tell my con law students, this is one of the things that's so interesting about constitutional law, is there are many cases that are still on the books that have never been explicitly or directly overturned, and yet they're completely inconsistent with many other subsequent cases that touch on them very closely. So you have to learn to navigate.
For one more question.
Hi, Professor Strossen. Thank
Hi.
you for spending the afternoon with us here. My name is James. My question for you is, and this kind of dovetails into your work for FIRE, but we have a distinction, of course, between public universities and private universities, and private social media platforms. So my question to you is your appeal to free speech to the private entities who are interested in regulating and controlling their own private property, more of an aspirational appeal to their best lights? And could you comment in that vein on efforts and talks of efforts here in the U.S. to regulate private social media platforms?
It's an excellent question, James, and one that I find very hard as a civil libertarian. And there's no exact definition, but I've had many discussions with my libertarian friends, such as at the Cato Institute, who are much more reflexively opposed to government legislation. Civil libertarians are not. So we sometimes think that government can do more harm than good in regulating the private sector. And for this reason, we also think that if whoever exercises sufficient power to, as a practical, functional matter, impede your freedom, that's something that, in our view, violates civil liberties. And I know there's a plausible argument against that. So the reason that I gave earlier, that Facebook and other social media companies, for all practical purposes, are exercising control and coercion and censorship of our free speech. As a civil libertarian, I want to find a solution to that, which would not necessarily be the free market solution that my libertarian friends would espouse. That said, I am deeply skeptical of government regulation, especially in such a sensitive area as communication. And when government has exercised that power in the past over the mass media, such as the so-called fairness doctrine, I oppose that. The ACLU opposed that, in part because, well-intended as it might have been, not surprisingly, it ended up not achieving fairness, but actually doing more harm than good. So I think that some kind of regulation should be considered, in particular antitrust regulation. I'm married to a free market economist, and he says, even the free market economists believe that markets aren't perfect, and at some point you need antitrust remedies. So I'm glad that that is being looked at now and considered now. But you're absolutely right. You hit the nail on the head that those of us who are the customer base and can provide business incentives to these companies that hopefully they would respond to. Right now, the customer base and the political base is exercising pressure in favor of more censorship, and those of us who are skeptical of that have not sufficiently raised our voices. That said, I will say that for the past several years, there's been a very large coalition of civil liberties and civil rights organizations that have complained to Facebook and to Twitter and the others that we don't like the way that they are enforcing their hate speech standards, because they are being enforced in a way that is discriminatory against racial minorities, against women, and against those who lack political power.
Okay, that's all the time we have. I could talk about this all day and have 1,000 questions in my mind. Thank you all so much for coming. I want to say 3 things.